We have quorum, so welcome everyone to this special continuation of our Governance and Policy Committee meeting. So I'll open with the land acknowledgement. Please stand if you're able. We acknowledge we are hosted on the lands of the Mississaugas of Anishinaabe, the Haudenosaunee Confederacy, and the Wendat. We also recognize the enduring presence of all First Nations, Métis, and Inuit peoples. Miigwech. So we'll start with declarations of possible conflict of interest. Does anybody have a conflict to declare? Hearing none. Next item is delegations. We have no delegations this evening. So on to item number 4, which is committee reports. All of the items under number 4 are reports from the Bylaws Review Committee. So 4.1 is the committee meeting from March 20th, 2025. And I'm going to turn that over to the chair of the committee, Trustee Laskin.
Thank you very much, Madam Chair. There are 3 different reports of the Bylaw Review Committee's work here. They build on each other as we've been getting through the work that we've had before us. And there will be one business arising motion coming from the after these 3 are approved, Madam Chair. And that is to ensure the committee can complete its work. So I appreciate the work of the committee members, which are Dan McLean, Debbie King, and Deborah Williams, and to our staff, Vitaly Plotnikov and his staff, and to our Associate Director, Leola Plon. And I'm going to turn it over to staff now to present. Thank you, Madam Chair.
Good afternoon, everyone. I'm pleased to present reports of the work of the Bylaw Review Subcommittee. As was mentioned earlier, it's a culmination of a variety of reports that we worked on a rolling basis. What we'd like to do is really to focus on some final products so that you are aware of what we'd like to do. I would like to, and again, we focused on 3 things: the Code of Conduct Complaint Protocol, and that is something that has been changed through legislation and regulation. We also made some relevant changes to the Code of Conduct to align with the complaint process. So that's item number 1. Item number 2, not as time sensitive. We are ahead of the game. However, it's important changes to our governance functions, which is our attendance participation in meetings. And so the Bylaw Review Subcommittee has come to a recommendation on changes to the existing governance procedure. And although I won't be speaking to it today, the 3rd large chunks of work that the Bylaw Review Subcommittee has been focusing on is to actually do a thorough review of the bylaws. I would ask if we could start with the slide deck for Complaint Protocol PR 708, if you're able to share that as well. Do we have that? Okay. Bella is sharing. There we go. Okay, so I will provide highlights of the proposed changes that the Bylaw Review Subcommittee has put forward. And before I do so, I do want to thank Vitaly and his team for a tremendous amount of work in a very short period of time, but also the members of the Bylaw Review Subcommittee. It has been an excellent working relationship. A lot to do, but we've managed to approach it in a way that we have made every effort to reach consensus, and I think we have really good product here. So I will move forward relatively quickly because we don't have tons of time. Next slide, please. A little bit of background context. TDSB was one of the first school boards to establish a board member code of conduct and integrity commissioner process. Not all school boards at that time have it. This is now mandated under the Education Act for all school boards. In the second bullet point, you see the specific Ontario Regulation 30624 that imposes the new integrity commissioner and code of conduct requirements, and we'll go through them in the slide presentation. All of you are aware, essentially, the code of conduct integrity commissioner process really is to outline a process to try to resolve complaints. The next slide, please. This slide really is a summary of the proposed key revisions. I won't go through them all, but we will, over the next few slides, go through some of the major ones. Next slide, please. Under the old code of conduct, members of the board, i.e. trustees, staff members and members of the public were able to file a complaint. That old process went directly to the integrity commissioner. What we've done here is propose to preserve the status quo, but the routing and the process is actually quite different. I point your attention to the definition of member of the public, and this comes from our current set of bylaws. Members of the public means a member of the TDSB community, including parents, guardian, caregivers, students, and volunteers, residents of the City of Toronto, and individuals or organizations serving the TDSB community. So the intention is to enable this process to serve the TDSB community and not beyond. Next slide, please. One of the active discussions that we had, and I think there's a general consensus that finding a resolution before the complaint starts, while the complaint is in process, is probably a strong and positive way to deal with conflict. One element that is not in regulation, but is something that the bylaw review subcommittee has recommended, and OPSPA has have recommended in one of their templates, is to include what we call a voluntary pre-complaint process. Before a complaint is ever filed, if an issue arises, there's an opportunity to try to resolve the matter. And again, this is voluntary, so no trustee is required to undertake this process. But and I think in practice, this happens fairly often, but at the same time, we wanted to codify this in the protocol. I should note the second last bullet point, even if you do engage in this voluntary pre-complaint process, it doesn't suspend the timelines to file a complaint. And later on, you'll see that there's a 60-day timeline or a deadline to file a formal complaint. If you engage with this process, the time doesn't stop ticking. It continues to tick. So it's important that trustees are aware of that. Next slide, please. So we've just spoke about a voluntary pre-complaint process. Now we're into the formal complaint process. And this chart I hopefully will be very helpful to members looking at this. On the left-hand side, we talk about who can file a complaint. There's 60 days. And we talked about members of the board, staff member, members of the public. There's an email address that has been set up to receive the complaints. Once a formal complaint has been received, there is a requirement to distribute the complaint to a variety of individuals. This includes all members of the board, the recipient, or the person who's the subject of the complaint, and the director's office. And then you head into the fourth column, which I'll call for now the cooling off periods. It's called early complaint resolution process. It's really an attempt, once the complaint has been filed, there's an opportunity for parties to try to resolve it again if there's an interest. There's no requirement to do so, but again, it's a period of time for people just to essentially cool down and see if there's a way to do so. Within this 20-day period, the chair's office, which is receiving the formal complaints, will be forwarding to the integrity commissioner the complaint and logging in and tracking the complaint. So there's a lot of administrative work that's happened behind the scenes. But again, 20 days to try to give it another shot. If it's not resolved, it is forwarded to the integrity commissioner. And you'll see in the remaining columns of the chart, there are a number of timelines associated with what happens once it goes over to the integrity commissioner. And the second last column, integrity commissioner has a number of steps they have to do before they start the investigation, the timelines to do the investigation, what happens once they finish and notify the parties. And then under the regulation, something brand new for TDSB, there is an opportunity for either the board of trustees or the complainant to submit an appeal. This is brand new. And again, there are timelines associated with it. It's very critical for all trustees to understand that this entire process must remain confidential. And so in the administrative processes that we have, we reiterate the confidentiality. It is critical to the success of this process and proper governance functioning if we maintain confidentiality on this information. And I will continue to reiterate that because it is so critical. Next slide, please. So once there is a formal complaint filed, there's a variety of ways in which it can be submitted to the office of the chair. As I mentioned earlier, there is a email that's been set up, trusteecomplaint@tdsb.on.ca, and the sharing of that information. Next slide. I won't go through this again, but essentially this details the early complaint resolution process. There's an opportunity, although no requirement, to engage in private mediation. Next step, please. Very critical to take a look here. If it's referred to the integrity commissioner will do an initial assessment to see if what we call a threshold assessment, and that is normally done within 14 calendar days. There's an opportunity for the integrity commissioner to determine that perhaps the complaint is late, so beyond 60 days, it's filed in bad faith, or it's frivolous or vexatious. And if the integrity commissioner finds that, the integrity commissioner can refuse to commence an investigation, and their decision is final. There is 90 days to conduct the investigation and make the findings. Next slide, please. The next slide talks about the sanctions, that the power of the integrity commissioner to issue sanctions if there is a finding of a breach of the code of conduct following the investigation. If there is no finding of a breach, there are no sanctions involved, the matter is closed. If there is a finding of a breach, these bullet points outline what's in the Education Act, what the integrity commissioner can determine. So it's not a recommendation anymore to the board to make a decision. It's the integrity commissioner's determination. Some of these you'll see include changes to your honorarium, including requirement to pay it back if necessary, attendance, participation as a member or as a chair in various meetings or in committees, and any others, and some broad language. For example, any other sanction that the IC believes would promote compliance with the code of conduct. So a broad authority to do so. As I mentioned, the next slide, please. The appeal process is also brand new. At this point in time, we don't have any information from the province, I don't believe, on what this appeal process would look like and how to commence it and what forms are used. However, the information on this slide reflects the changes to the regulation. Timelines to do so, 15 business days. And either the board or the member who is the subject of the complaint can commence an appeal. Next slide. Payment of legal costs. This is a set of provisions that were in our old code of conduct, where there's an opportunity to have reimbursement of some legal costs depending on the stage at which the complaint is at. And so what we have here is a proposal to have, for example, up to $5,000 to respond, for a trustee to respond to a complaint. So not to initiate, just to respond. To respond to an appeal, up to $10,000. If there is the stage where we get to judicial review, there could be reimbursement for up to $20,000 if it's not already covered by an awards cost awarded by the court. We had an opportunity to discuss what will happen if when the reimbursement of legal costs would be triggered. There are two options we want to share with GPC. Option number one, we will consider, the board will consider reimbursement if the IC or the appeal panel concludes that there's been no contravention of the code at all. Or option two, there's been finding of a contravention, but no sanctions were issued and applied. So this is something for the committee to think about how they would like to see the procedure. Next slide, please. And because of all the changes to the complaint procedure, we then went backwards to make sure that our code of conduct reflects the changes that were in the complaint procedure. You'll see some tweaking to definitions. We added the voluntary complaint, pre-complaint procedure, and additional small adjustments to the code. That is it for the complaint procedure and the code of conduct. Perhaps it might be helpful to entertain questions at this stage before we head off onto the attendance and participation in board meetings.
I need to put this on the floor for questions first. Okay. Yes. Okay. Are there questions for either the committee or staff on item 4.1? Trustee Laskin?
If there are no questions, Madam Chair, I'd be happy to move the motion.
Sorry, I have a
Madam
question
Chair, I have one single question.
in the chat box.
Is that possible, the staff can send the slide deck to our email? So we can, or is it just,
Yeah, asked already.
review in person?
Yeah, we can send it by email. It is also, the presentation is also in eScribe. It was actually shared for the previous GPC meeting. So it is actually also in eScribe. But staff will send it out now.
Thank you very much, Madam Chair.
Thank you. And Trustee Sishkandaraja?
Thank you, through you, Madam Chair. So do we have to move option A or B?
Oh, yes, that is correct. We have to decide on either A or B for the appeal and compensation.
That's in the procedure.
Is it possible to back up on the presentation to put on that on screen? Sorry, Trustee Sishkandaraja, do you have other questions while we get that back up
Sure,
on the
yes. Just through you, Madam Chair, I would like staff's feedback on the options. If I'm understanding it correctly, is option B the more expansive option, like it covers more grounds, and option A is more restrictive? Is that a correct understanding?
Through the chair. So option one is a little more restrictive because you have to find whether there's a contravention or not. Option two, in the event that there is a finding of a contravention, but essentially the contravention was so minor that the integrity commissioner made minimal or no sanctions were applied. So you've seen in other reports that even despite the fact that the code may have been breached, the integrity commissioner felt it wasn't of such serious nature that it required some sort of sanction. So option number two is a little more, I would say, generous when it comes to the ability to seek a reimbursement, because in that case, there is a finding of a breach. But essentially, no sanctions were applied.
Thank you. Through you, Madam Chair, is there a reason why, just to get the thinking of staff, why these are the only options? Like, is there what if there is a sanction applied, but a person or a member of the board still wants to appeal, why would their legal costs not be covered, if I'm understanding this correctly?
Through the chair, we try to follow the spirit of the previous code of conduct. And option 1 and 2 is one level and another level of the way in which reimbursement was done under the old code of conduct. This is ultimately a board decision on how you wish to proceed with legal costs. Staff don't have a recommendation. But certainly the options that were presented here are aligned with the thinking of the old code.
Thank you. It seems like Trustee Pei has a question, so I'll come back. But I do want to put it out there to trustees on this committee, how they're feeling. I would like, through you, Madam Chair, if there's any comments on if we should make it more expansive, have an option 3, if you will, just to cover any legal costs for any, for anyone who's responding to a complaint. So yeah, I'd like to hear what people are thinking, right? Because right now, through you, Madam Chair, it's easy for us when we're not in the position of being accused of something to choose a more restrictive option. But I just, obviously, hopefully none of us end up in that situation, but worry that we don't want to change the rules at a later time when we're already in that situation or wonder why the rules are the way they are. So I'll think more about that, and I'd love to hear from other trustees.
So Trustee Laskin and then Trustee Pei.
Thank you, Madam Chair. I actually support option 1. I don't think we should be reimbursing any costs for those that are found to contravene the code. That's my comment. Thank you.
And Trustee Pei.
Thank you, Madam Chair. I just want to have some clarification from the staff. So what are current bylaw right now? If some member was, a issue complaint and the member, her legal services to respond to complaints, are they reimbursed for anything under its current bylaw? Yeah, the reason I'm asking is one the member actually made a complaint to me, and then I wrote a letter back to the complaint, and I see integrity commissioner. Then the other member dropped, the complaint. So in that case, I incurred a legal cost.
Trustee Pei, just can I stop you there? Investigations and complaints are confidential. Even if they're your own complaints, they're still confidential. So could you please refrain from
actually,
discussing
I'm not
the
mentioning the
details?
name. I'm just mentioning the procedure, Madam Chair. I'm not mentioning the member's name. I'm mentioning the whole procedure. I want to understand more from my personal point of view, right?
So through the chair, I can answer that question without, I can answer that question without this additional context. So it's not covered in the bylaws. It's actually covered in the code of conduct. So the old code of conduct, I'm having trouble saying that. So there are provisions in there that essentially reflect the ability to seek a reimbursement through that process. It's a little not the same as this one because there's no appeal process at that time. So under the code of conduct, there are an opportunity to seek reimbursement of legal costs. So
so what the process is that? Is like, should I submit my response or application to the chair, or is like who should I do it? Like it's like I just want to understand the whole process,
Yeah. So through the chair, because this the code of I would suggest reading the code of conduct, just familiarizing the old code of conduct, I should say, because that provides detailed information on what steps to take. And again, this is a governance procedure. The staff's not really involved in adjudicating or assessing this. Of course, we will support in any way we need. So the process is outlined in the code, not the bylaws.
Okay. Anyway, so just for this matter, just assume is is like a similar matter may happen to other trustees. For this kind of matter, like who is a contact person we should approach
It's the chair.
regarding reimbursing legal cost?
Through the chair, I don't have that memorized at this point in time. Perhaps I'm happy to answer that question later on the specific contact person for that. Again, it's not a provision that's been used as far as I'm aware of frequently, so I don't know the answer off the top of my head.
Okay, thank you very much.
I can certainly follow up with you, Trustee Pei.
Thank you very much, Associate Director Pang. Madam Chair, through you, I have a second question regarding this option 1 and 2. So I'm reading that is there's a maximum $5,000 responding for response to complaint, and there's 10,000 maximum for appeal, and then 20,000 is like for judicial review application. So through you, can I ask the staff explain to me what's the difference between the appeal and the judicial review application? What's the difference between these two?
Sure. Through the chair. So the appeal process is a process that the Ministry of Education under the Education Act and Regulation has built in that allows either the board or the member who's the subject of the complaint to challenge the decision of the Integrity Commissioner. And because we don't have any information from the ministry on the appeal process, it's a little bit challenging for me to explain whether it's automatic or whether there's a vetting stage in advance. So that's one aspect. But the appeal, the people who are hearing the appeal are not judges. They will be a panel of other types of other integrity commissioners or whoever the ministry appoints as members of the appeal panel. So it does not go to a court at that stage. If after the appeal panel makes their decision, let's say it's not in favor of the member who is the subject of the complaint, and the member wishes to try to challenge that further, the ability to seek judicial review is extremely limited. It goes to a divisional court. However, it's not based on a challenge necessarily of the facts. There are very limited, there's a very limited ability to seek a judicial review. And even at that step, you have to get permission from the courts to be able to seek judicial review. I would say that it is extremely rare for a judicial review to occur. But again, the judicial review is a court. The appeal process is a panel of appointees from the ministry.
Okay, got it. Thank you very much. Through Madam Chair, I have a question regarding the option 1, 2. I understand option 1 is virtually the member has no contribution of a code of conduct. So that may include the decision by the Integrity Commissioner, which in favor as members of favor, and also could be include if the complaint withdraw the complaint, right?
Through the chair, there is no, based on the discussion we had at the bylaw review subcommittee, that was not contemplated where there is legal reimbursement in the event of a withdrawal of a complaint. Again, this is something the GPC and eventually the board can fashion, can make whatever decisions it would like to address that situation. But at this point in time, based on our current draft, we don't contemplate that. It really has to involve a decision of the Integrity Commissioner.
Yeah, but was this one the member make complaint which has no evidence? So I mean the member, I mean as far as I understand, anybody can make complaints to us now. right? If somebody make a false complaints to us, we have to hire, a lawyer to respond that complaint. But then the members all of a sudden, whoever is making the complaints and just drop the complaints, but we still incur cost, right? And there's no way for IC to issue a decision that there's no contribution code of conduct. Virtually there's no complaint anymore, but there's still cost exist. So in that case, I mean, the board just do not reimburse to the member. I think it should be option 3 then, right? If the complaints initiate, but unfortunately drop at a later time, and the member still entitled for legal cost, right? Because we're facing right now, I think we're open the floodgate right now. Everybody can issue complaint to us, right? I don't know. I mean, it's like I just don't know. I mean, it's like they're I'm just really worried. Like there are going to be a lot of complaints come to us now, especially regarding the budget. It's so contentious issues, right? I'm just asking the question through Madam Chair. Has the staff ever thought about this whole process regarding complaint which is going to be withdrawn later on?
Yeah. Through the chair, just wanted to clarify, who can complain is the same then as it is now. So it's not opening necessarily the floodgates. It's the same group of people who can file the complaint. So I just want to just clarify that. And to as was referenced in an earlier question, these are not the only 2 options, but these are the 2 options that the bylaw review subcommittee is recommending to GPC to consider. Of course, there could be more. So you can set a higher bar, you can set a lower bar. But it was important that the bylaw review subcommittee and staff at least propose a pathway forward. So if there's a desire to introduce different options or a variation of option 1 and 2, again, this is why we brought it to the GPC to make the decision.
Yeah, so I just, through Madam Chair, I just want to understand. So we only have option 1 and 2, right, to vote for. Is this a motion about it, or this a report about this option? We can only choose one option, right?
Through the chair, this is a recommendation of the bylaw review subcommittee of options 1 and 2. Again, the GPC committee can put forth a different option if it wishes and vote on it.
Okay. And can I make an amendment, Madam Chair, for
yeah.
option 1? Okay, for option.
Do you want? Okay, sorry. Can you explain it and then type it out and send it to Ms. Joseph Dowers?
Okay, because I think I'm probably going to choose the option 1. If the members have no contribution in the code and then the judicial review is in the members' favor, then we should reimburse the members' legal cost. At the same time, I think we also need to reimburse the members' legal cost if the complaint was withdrawn later on. Because that's also indicating there's no contribution of the code, right?
So through the chair, if I can assist, I think what you're suggesting is under the language of the presentation in option number 1, there has been reimbursement will be considered if the IC or appeal panel concludes there's been no controversy. We'll have to add a different category that says the complaint has been withdrawn.
Yeah.
At a certain point, and again, I'm assuming withdrawn before it goes to the integrity commissioner complaint or at any part of the process. So it could be withdrawn after the IC receives it as well. So
absolutely, it could be during the appeal process. Yeah, either one, right?
So a formal complaint has been withdrawn. Is that what you're?
That's correct. Yes, that's what it really means. Thank you, Associate Director Pang. Yeah. I just want to make sure it's cover everything, right?
So, so
Sorry.
basically adding, so if there's no controversy, the complaint has been withdrawn.
At any stage of, at any stage, yeah.
Informal,
An informal
a
complaint.
formal.
A formal complaint through the chair.
Okay, we're just gonna work on wording here. I'm gonna go back to Trustee Fitzkandraja, unless there's anybody else on this.
I
Thank
think
you. Thank you, Madam Chair.
Trustee,
I'm done.
DeVitis hasn't spoken yet.
Oh, okay, thank you. Trustee DeVitis?
Thank you. My question is more about the process of the process here, just so I understand and I can follow. There are a number of items here, 4.1, 4.2, 4.3, and they're similar. But Chair, would you be able to walk me through what it is that we're approving today? So I understand what's coming to board later. Yeah.
Right now, we're on item 4.1,
Yep.
and we're looking at the approval of the revised code of conduct. So PR
708.
PR 708. And this is the complaint, sorry, this is an extension of the code of conduct. This is the complaint protocol for the member board of conduct. And what's being discussed right now is that in our existing code of conduct, there is a mechanism to seek reimbursement for legal costs, to seek reimbursement from the board. It's not a guarantee. It's a mechanism to seek reimbursement.
Yep.
And so the subcommittee discussed that and put forward some recommendations for the committee to consider in terms of if the board was going to continue to reimburse costs, what would that look like?
Yeah, and that's 4.11 is does 4.1 include number 2 as well, P039, attendance and participation, or does that come later as a separate vote?
We haven't gotten there yet.
You haven't gotten there yet, and that's what I wanted to know. And then my last question is because some of these reports seem very similar on my reading on them, and not having been there for the previous 2 meetings for the bylaw subcommittee. So what's the difference in 4.1 and how we're dealing with, say, P039 and 4.2 and then 4.3?
Trustee Laskin, correct me if I'm wrong, but 4.1 has decisions that have to be made by, or recommendations that have to go from this committee to the board. And 4.2 and 4.3 are updates from the previous committee meetings. Or, sorry, the code of conduct under 4.2.
Sorry, Madam Chair, I believe in 4.1, the only thing that we're actually approving is 708.
Right.
In 4.2, we're actually approving P039 and
$75.
P075. So in the first report, it's just PR 708. In the second report, it's P039 and P075.
Okay, through the chair, a bit confusing because you do have some recommendations for 4.1 on section 2 for P039. It says currently and then recommended. So we're not approving the recommendations in 4.1. They come in. I should only be looking at the recommendations that come in for 4.2 or 4.3.
In 4.2,
Yeah.
it was, we referred it back to staff.
Okay.
I mean, in 4.12, the recommendation there, we referred it back to staff. We didn't, the committee didn't approve it during that meeting.
Okay.
We approved it at the next meeting. So if you look at the recommendations before us, the PR 708 is here for approval under 4.1. 4.2, the recommendation from the committee was to refer it back to staff under 4.1. When we get into 4.2, there are different recommendations. Like it is confusing because the committee's work has
Rolling.
Yeah, rolling. And we didn't reach approval during the meeting of March 20th on PO 39, but we did reach approval on PR 708. So does that make sense to you? So we're just on.
I can follow it while you're saying it through the chair. Trustee Lasking, through the chair, do you know the format that this report's going to come to board? Because they'll be really difficult for us to follow, like what the final approval is from the different layers of it. And I think that may be difficult by the time it gets to board.
It would be
if
the
it comes in this
approvals of
format.
GP. My understanding is it would only be the recommendation approvals of GPC that would flow to board. These
Okay.
bylaw subcommittee reports here, and it's only if GPC makes a recommendation to board that will flow to board. But thank you for raising it. And I look at staff and I believe they will try to make it as clear as possible with the documents attached. Because what happens sometimes in a board agenda is you have to keep going back to previous agendas. So I will request that those items that we're actually going to approve at board be actually linked or in the board agenda package for clarity.
Thank you. And that was about process. I did have a question of substance in terms of one of the recommendations. So in 4.1, but I guess the question should come after the approval for 4.11, correct? If I have a question about 4.12?
Right, and respectfully, and sorry, Madam Chair, if I can ask, I am wondering, since 4.12 was just referring it back to committee, I think you should hold the questions when when 4.2 is presented, because that's actually for approval of that item. Does that make sense to you, Trustee Didavides?
For me, it's fine. I'll follow the lead of the chair through the chair.
Yes, and yeah, apologies because we didn't get to this at the last GPC meeting. There have been additional meetings, and so everything kind of flows together into this meeting here.
Yeah.
No, fair enough. Thank you. I'll go back on the list for 4.2 later. Thank you.
Okay, perfect. Thank you. Do you have anybody? Or we're back to, okay, Trustee Siskandarajah?
Thank you, Madam Chair. I know Trustee Pay said he wants to move first, so I don't know what's happening with that. But I just want to voice that I am in support of option 2. I just prefer the expansive option, especially if this was part of our previous iteration of this. So that's just my comments, and so I would vote against option 1. But yes, so I don't know if I should move that or if others who've already indicated that they want option 1.
I think procedurally, Trustee Pay is going to move option 1 with an amendment to broaden option 1. And then procedurally, I guess now if that fails, then we would go to option 2.
Okay, so just for clarification, through you, Madam Chair, so we would do 2 votes. One vote would be to pass the amended language.
Yes.
And then on the option 1. Right? Because okay. Just want to clarify, because I might be in favor of the language, but then not of the entire option. Oh, okay.
Okay.
Thank you.
Thank you. Do we have any more questions regarding, the PR 708 complaints procedure before we go to an amendment and then a vote? Nobody else?
No.
Okay.
Madam Chair, may I just clarify something for Trustee Siskandarajah?
Yeah, go ahead.
In the previous version of the Code of Conduct, everything was contingent upon if in fact the member contravened the code. Option 2 is brand new. It didn't exist before. I just wanted to clarify that because I think there was an assumption that that language was in the previous version of the code and it simply was not. So staff can clarify that, but I just wanted to clarify. Thank you.
That is correct, through the chair.
Madam Chair, may I have ask another question, please?
Go ahead, trustee.
For clarification. Thank you, Madam Chair. I a little bit confused here regarding option 2. If the member contravene the code of conduct, why there's no sanction there? Because in the past, I understand, I see, indicate some cases there's contravention of code of conduct by the member, but the board decided is overturn that decision. But now is virtually, their only IC is going to be make a decision for the judgment of violation code of conduct, right? So if the violation occurred, why there's no sanction? I just don't understand.
In the current code of conduct and the new code of conduct, or under the ministry's guidelines, it's the same. The integrity commissioner has the ability to determine a contravention of the code and not recommend sanctions. So they could, for lack of a better term, say, I believe the trustee behaved badly, but I'm going to take it in good faith that they've apologized and moved on, and I'm not going to impose any sanctions. So there's every case is different. It's up to the integrity commissioner whether or not they lay sanctions and what kinds of sanctions they lay. There's no absolute requirement for them to lay sanctions if they found a breach of the code.
Okay, understand. Okay, now I have a better understanding about this option 1, option 2. So, Madam Chair, is sorry, I apologize. I would, in this case, I would vote for option 2 with my amendment. Is that possible? I can add my amendment to option 2 instead of option 1?
Yeah, but I'm going to ask for a quick recess.
I apologize, Madam Chair. Sorry, I misunderstood this between these 2 options. Okay.
Yeah, we just need a few minutes to straighten that out.
Thank you very much, Madam Chair.
And cut the mic. Okay. Thanks, everybody, for your patience. The amendment is on the screen for option 2. So I need um, a mover and a seconder for the amendments.
Madam Chair, I will move the amendment. And I would open the floor to my colleague to second.
I will second, Sir Raja.
Thank you.
Thank you, Trustee Conrad.
Trustee Laskin?
Are you opening the speakers list on the amendment, Madam Chair?
Yes.
Did the movers and the seconder want to speak first?
Did the mover and seconder want to speak first to the amendment?
Yeah, Madam Chair, I think this is important regarding this amendment because just through my personal experience, I've been through the process of official complaint. It's a primary matter. I just gave you example that is, after, I had a lawyer and the lawyer read response to the complaint, the complaint was dropped. So I just feel like we should really make this option more broader to cover more bases. So we don't really subject, to any kind of complaint that it would cost us financially to defend ourselves. Okay. We all, have our, daily job, we're busy. But sometimes when we subject, this kind of complaints with no evidence, we're really, really vulnerable. So I just want to think this motion really brought at the base of reimbursement process is also, I think, is been a really fair process to trustees. Thank you very much, Madam Chair.
Trustee Siskandraja?
I'm okay.
Okay, thank you. Trustee Laskin?
Thank you very much, Madam Chair. In the previous version of the reimbursement provisions, they were all of them were contingent upon if the member was found not to have contravened the code. I understand and will support reimbursement if a formal complaint has been withdrawn, but not attached to option 2. I do not believe there should be any reimbursement to any member who was found to contravene the code. Respectfully, I won't support the amendment to option 2 or option 2. If this passes, so be it. But if it doesn't pass, then I would support the complaint being withdrawn attached to option 1. Thank you, Madam Chair.
Thank you. Are there any more questions on the amendment? See anybody's hands? No, verbal?
No,
I think he's right. Oh, okay. We're gonna pull this up on eScribe. Just 1 second. Okay, the vote is the vote is open.
Trustee Pay in favor?
Trustee Nunziata in favor.
I can double check.
Hello, Chair. The vote has carried.
Then thank you, Madam Chair. I'd be happy to move the procedure then with the option 2 as amended.
Sorry, that was just for the amendment.
Oh, sorry. I thought it was for option 2 as amended.
No, so we voted on the amendment. Now we're voting on, we accepted the amendment and now we're voting on option 2 as amended.
That doesn't make any sense. It's the same vote.
So what's been put on the floor, oh, sorry, I need a mover and a seconder to put option 2 as amended on the floor.
Trustee Bay.
Thank you.
Ms. Ganaraja?
Thank you. And could we open the vote?
Trustee Pay in favor.
Trustee Nunziata in favor.
E-scribe is open. Carried? Okay, and that has carried. So option number 2. So now we need to go back and approve we need to, approve PR 708, complaint protocol for board member code of conduct as a new procedure. So are there any further questions on PR 708? If not, I need a mover and a seconder. Trustee Laskin,
Ms. Ganaraja?
thank you. And could we open the vote, please? Thank you. Vote's open.
Pay in favor.
Conjugal Singham in favor.
Trustee Nunziata in favor.
And that carries. Thank you. So item 4.1.2 was actually, the recommendation here was just to refer the report back to committee for further work, or back to staff for further work. Yeah, you need to vote. No, okay, so we're going to move to item 4.2. There are 2 items here that the committee needs to make a recommendation to board. 4.2.1 is policy 039, attendance and participation in meetings. This is a new policy, or sorry, no, this is the updated policy. It was formerly the electronic participation in board and committee meetings. This is here because the ministry has made new requirements that start in September of 2025 for mandatory participation by board members in person at full board meetings and committee of the whole. And Associate Director, take it away.
Sure. And through the chair, we also have a slide deck to talk about this. So if
Thank you.
Bella can share that. Thank you. And through the chair, I should also mention this also relates to item 4.3, where we have the final recommendation.
Okay.
All right, next slide, please. So this relates to changes that were made to the Education Act and related regulations on attendance and participation in board committee meetings.
Excuse me, Madam Chair. Should this not wait to be presented until 4.3? Because this also was referred back to staff, but in 4.2, the recommendation is to approve PO 75. So I'm just asking, Madam Chair, if the presentation should wait until we're actually voting on something, which is 4.3.
And through
And
the
4.2 is PO 75. I mean, it's up to you to present it now is no problem, but we're not actually voting based upon 4.2.
Through the chair, if I can recommend that we focus on PO 75, which is related to the complaint procedure. It's minor changes really to reflect the complaint procedure. And so that's 4.2. And item number 1 in 4.2 is just an interim report that we had. So my preference is to focus on board member code of conduct, which is item 4.22 for now.
Which is here to be approved.
Which is here to be approved.
Great.
And then we'll eventually, once we finish that, then we can do the most current set of recommendations on board attendance and participation in meetings.
Okay, that is fine with me. So we will come back to the participation board meetings and we're going to, so we just approved the complaint procedure
Mhm.
that is partnered with Ducks. We did approve interim board of conduct, or sorry, we did approve an interim member code of conduct earlier this year. This is the final version with the new procedure. Okay.
And through the chair, yes, we did, or the board passed a interim changes because of all the changes that were required were quite time sensitive. The bylaw review subcommittee then did a lot of work, just working on the details of the complaint procedure. And because of now finalizing recommendations on the complaint procedure, we then had to go back and make sure that the board code of conduct, so a policy, is aligned. Sorry, there is background noises. Oh, it's. Try this one again. Testing. Our apologies, there's some sort of technical issue. I'm not sure if those online can hear what was happening. Essentially, the changes to P75 board member code of conduct now align with the complaint procedure. So we are requesting that the revised code of conduct be approved. Thank you.
There we go. Are there any questions on the revised board member code of conduct? As listed in the report under 4.3, sorry, 4.3, 4.2.2. Okay, seeing no questions, could I get a mover and a seconder to approve the revised board member code of conduct? This is policy
Trustee
P.
Pay?
Thank you. So I have trustee Laskin and trustee Pay. And the vote is open.
Trustee Pay in favor?
Trustee Nunziata in favor.
Okay. Okay, and that carries. Thank you very much. So our last item is both 4.2, 4.3 updates, but we're voting on the item under 4.3, which is the recommendations for P039 attendance and participation in board and committee meeting.
Thank you very much. And as you can tell, the bylaw review subcommittee has been very busy working on multiple procedures and policies. And so this is the last one at this point in time. So if you can start the slide deck again. Thanks, Bella. You might recall TDSB had a governance policy called electronic participation in board and committee meetings, P39. It was actually a lot more than electronic participation in meetings. So what we wanted to do is make sure that the title of our procedure better reflects the content. And the old title really reflects the regulation, which probably should be amended. So the new, next slide, please. Oh, sorry, I think we're waiting for it to be shared. I can start while we wait until it's shared. Okay, thank you. So it's a slide deck for attendance and participation in board meetings. P039. Thank you very much. So a number of changes are to come into effect in September 2025. And you may be aware of perhaps the most visible one being in-person attendance at board meetings and committee of the whole meetings. And so we did have to update all our procedures to reflect the changes in law. Next slide, please. So under the Education Act, for regular board meetings and regular committee of the whole meetings, the following individuals must be present at every single one of those meetings. All members of the board and the director or the director's designate. It's important to note that in-person attendance requirements does not apply to special board meetings, and it does not apply to special committee of the whole meetings. There is also an opportunity for members to seek an exemption in advance prior to the meeting, a written approval from the chair to be able to attend the meeting electronically under certain restricted circumstances, and we'll go through that in more detail later on. And then there's also a provision that for school closures, I won't spend any time on that. It would not really apply to here. So physical attendance requirements, next slide, please. For committee meetings, in here, you must have at least the committee chair or their designate and the director or their designate. And the committee chair can participate electronically if another of the member of the committee, who is also a member of the board, is physically present. So at all times, you must have at least one trustee physically present in a committee meeting. Next slide, please. So here we reflect the changes to the legislation. So all trustees must attend in person unless you obtain written approval by the chair in advance. If one of the circumstances that's listed in the sub-bullet points apply. So if the distance from your residence to the meeting location is over 125 kilometers, if the weather conditions don't allow for safe travel to the meeting location, if there are health-related issues affecting the board member, preventing them from attending, excuse me, in person, if there's a disability that makes it challenging to be physically present at a meeting, or if there are family responsibilities, that term is the term that's used. And there is a little more information later on. We'll go through about what a family responsibility looks like. So it's important that all trustees, if they seek to participate in a meeting, a regular board meeting or committee of the whole meeting, they must obtain the approval of the chair before the meeting begins. We had some discussion on what that in practice would look like in order to make it workable, given the demands on the chair's time, and to make sure that there's no inadvertent non-approval. So if there are planned reasons or expected circumstances, so you due to a health-related issue, you've, for example, encountered a severe flu or something like that, then the members should be submitting the request at least 2 business days before the meeting begins. And there will be a lot of work behind the scenes with the chair's office to make sure that the information is monitored, the requests are monitored. Obviously, there may be a provision for emergency or last minute circumstances. So what the bylaw review subcommittee has suggested is under unexpected circumstances, the member of the board must submit the request as early as possible before the meeting begins. One of the challenges for that, despite being as flexible as possible, is the regulation requires that the approval is obtained in writing before the meeting starts. If the request is submitted so late that it does not give the chair an opportunity to review and approve, there could be a significant impact on the member, and the attendance will be, you will not essentially attend electronically and be marked absent in that particular case. And there's additional consequences to that. There are, again, requirements that there must be at least 1 member of the board physically present in there. Next slide, please. And this is a very critical slide for trustees to note. Next slide under, it should say non-compliance. There we go. Thank you. A member of the board vacates, essentially loses their seat if they, and A is the existing language of the Education Act. If they are not, if they absent themselves without being authorized by resolution of board from 3 consecutive regular board meetings. So that's nothing new. That's the existing legislation. So if you're absent for 3 consecutive board meetings without prior approval by the board via resolution, you will automatically lose your seat. The second, section B, is reflecting the current changes to the Education Act. So if the member fails to be physically present at a regular meeting of the board or a regular meeting of the committee of the whole, unless their request to attend electronically is approved as set out in the policy, or so pre-approved by the chair in writing. And this is reflecting Regulation 46397. So very significant consequences if that request is not submitted in advance and approved in writing by the chair. Very critical to get it in early as possible. The subcommittee also made some recommendations on some decorum. So for example, turning on cameras if we are in private session, again, to ensure the confidentiality of the contents of the meeting. There are other changes in the PO 39, and we're happy to answer any questions. Thank you.
Okay. Do we have any questions about the new policy?
Chair, Madam Chair, I have
Oh, yes.
questions.
Yes.
Okay, through you, Madam Chair, I just want to seek some
Sorry, Chair,
clarification.
just in case it was missed, sorry, point of order, it just had my, my name up. I don't know if I
Oh,
was
I'm
first.
sorry,
Yeah.
I apologize.
It's
Okay.
okay.
So Trustee
It's okay.
David,
It's
you
for the
go
chair. It's
ahead.
for the chair.
Okay, sorry. We have Trustee DeVitis, we have Trustee Pay, and we have Trustee Rajakula Singham. So
Okay,
Trustee
eh,
DeVitis, go ahead.
I appreciate that, Chair. My question's again about the rest of the report. So, any other elements that were considered as part of the first iteration of this report in 4.1, if they're not included in 4.3, are they coming back? Are they still being considered? Because there were some elements in there in regards to meeting time, delegations, other things like that. Are those things coming back at some point, or have they fallen off the plate at this point?
So my understanding, and I'm getting nods, is that those items that were discussed will come back as part of the broader bylaws review.
Okay.
So there's this new policy does impact back onto our bylaws and like when we hold meetings. And so there's some things that as a board, we now need to look at in terms of our meeting structure and other bylaws because of this new policy.
Okay, fair enough. Thank you. And those were all my questions. Then I thank you, staff, for the presentation, and thank you, Chair.
Thank you. And I believe that the survey that went out to trustees was meant to inform that other discussion too, correct?
Through the chair, yes. Remember, I talked about at the outset of the meeting that we are dealing with issues in 3 chunks. So the third chunk is not being discussed today, and the third chunk is about bylaws. And right now, we're just focusing on in-person attendance at meetings.
Okay, thank you. Trustee Pay.
Thank you, Madam Chair. I just want to seek some clarification from the staff regarding some changes in this bylaw. So number one is I heard is mentioning the staff mentioning if distance is the issue. I just want to understand why is the number 125 kilometers being chosen? Is there arbitrary or is just a reason for that?
Through the chair, it's in the Education Act.
Oh, okay. Okay, thank you. So, Madam Chair, my second question would be regarding one of the point you mentioned that is a 3 consecutive regular meeting, and then the next point is like if the member was missing from either regular meeting or whole committee meeting. So I just want to understand a bit more. Are we talking about 3 consecutive regular meetings, or we're talking about 3 consecutive regular meetings plus whole committee meetings?
Through the chair. So under the, a longstanding requirement of the Education Act is that a member must be attending 3 consecutive meetings, regular meetings in a row in order to maintain status as a trustee. Sorry, they cannot miss 3 consecutive meetings in a row. Sorry, I should make sure I clarify that. That has always been in the Education Act for some time now. So that's one, and this is admittedly quite confusing, but in any event, unless there's a pre-approval by the board that allows you to miss 3 regular meetings in a row, and we're only focusing on regular board meetings under that particular provision. The other issue is whether you can attend electronically or in person. And so I just want to make sure that we don't confuse that, even though it sounds quite confusing. And 3 consecutive meetings in a row, sorry, it should be said that. So under the policy, a member vacates their seat if they do not attend 3 consecutive regular board meetings without authorization by the Board of Trustees.
But Board of Trustees, not the chair? Because I
Not the
thought
chair.
we're writing requests to the chair, not the Board of Trustees, do we?
So, yeah, so the request to the chair has to do with attending, the ability to attend a meeting electronically versus in person.
Okay. Okay, all right, so,
So through the chair, if you refer back to the slide deck, slide number 7, it starts with the header non-compliance. A and B are very different provisions. So A is the trustee is absent for 3 meetings, regular meetings in a row. B is, can you attend electronically, or you have to be present in person? So 2 very different types of provisions, but if both if the trustee fails to meet the requirements of both provisions, those are the ones in which you can lose your seat.
okay, so, but if the trustee meets 3 consecutive regular board meetings for medical reasons, would that be like a granted for exceptions?
So, sorry?
For
Um,
medical leave, yeah.
So the provision number A in the slide deck, right? It talks about they absent themselves without being authorized by resolution of the
Okay.
board. So what normally has happened in the past is a request has been submitted by the trustee to the board. The board makes a consideration, passes a resolution authorizing trustee X's absence from regular board meetings. And that's the process that has occurred in the past.
Okay, so, okay, now I understand. So basically, being absent from the board meeting should be approved by the board trustees. Why, attending the board meeting electronically can be approved by the chair or vice chair if the chair requests.
Correct.
Okay, so how advanced that written notice should be submitted to the chair or vice chair?
Through, in the slide deck, we talk about if it's a planned occurrence, at least 2 business days, submit it in writing to the chair. Gives the chair an opportunity to make sure that they can answer. In our unforeseen urgent emergency circumstance, as early as possible, with the high risk that the chair might not be able to get to it and the consequences can be significant. So again, as early as possible, whether planned or not planned.
So if unplanned, Stu's request a written request, right? So
Through the chair. Yeah.
written request can be a text or had be email.
The Education Act isn't clear. It does not
I
specify.
apologize, Madam Chair. I just asked a question because I want to
Yeah.
make sure, what's a form of request will be accepted by the board, right? I don't want to, I read test, to the chair. I assume is that's a formal request. Then I said, well, you should write the email to
Yeah.
the chair. Okay.
Email would be the safest route forward because you would then have a paper trail essentially.
Okay.
And if I can add as well, all the finer details will have to be discussed with the chair's office.
Mhm.
We have involved these admin support staff there to assist with the complaint procedure and so on, the tracking of it, but also they would likely have a role in just monitoring the email and bring it to the attention of the chair. So the bylaw review subcommittee did talk about that in quite a bit of detail about the format, but it really should be by email. There's a record of the request. There should be a record of the response to the request, not on an individual's mobile phone that can be lost or a message that disappears. So by email.
Okay. Thank you very much, Madam Chair. Thank you, Associate Director Pang. I finished my questions.
Thank you. Trustee Rajagopal.
Thank you through the chair. Just two questions. My first is, how about a circumstance where you're driving to board and you're attending the private session of the board meeting virtually in the car? Would the expectation be that your camera is on during that time? Through the chair.
Through the chair, could you just repeat that question again? I'm just having trouble processing it.
Sure, through the chair, just say a trustee is driving on their way to a board meeting, and during the private session, a board meeting, just say they're in the car driving, would the expectation be that their camera be on at that time?
Through the chair, it should be the expectation that arrangements are made so that the attendance is not while driving. If you need to park. Again, this is a recommendation on the decorum of attending meetings in private so that that the member is visible. So there's engagement there. There's confirmation that the meeting is held in confidence. So if you're driving in a car, but you also have others in the car, it's critical. It's one way of assuring a confidentiality. But also would be a much better practice that you're not driving while in a private meeting.
Thank you, through the chair. My second question is, for those of us that need to finish another job and then head to board for 4:30, sometimes it's about an hour commute. So sometimes we may be joining electronically. In those circumstances, just if we're on our way to board and we're joining like the first bit online, would that require written approval, or because we're on our way to board and we're just doing maybe an hour or so online electronically, is that okay?
Can I clarify, does the Education Act actually, it doesn't actually speak to being late, correct? Like, it's attendance overall.
Through the chair, that's correct. It's the Education Act is quite clear on that. The Education Act does not address whether you're running late for a meeting. This is something that the bylaw review subcommittee has discussed quite regularly. It could be addressed when the subcommittee talks about the bylaws portion of their work, about whether the private session is necessarily a committee of the whole. Right, so that seems to be the challenge. Some of the ideas, were whether to schedule it to another time later on so that members can attend. So there's a lot of discussion that's still active about how to address that particular issue. But at this point in time, there is no allowance in the Education Act to enable someone to attend electronically if they're running late to the meeting.
Thank you through the chair. I'm just being very careful because I know we have a few months until these changes go into effect. But given, the current context we're in, it's important that we're thorough in different situations that some trustees may have, and we're able to be clear in our decision making. But that's it for me now. Thank you.
Trustee Laskin, can I pass the chair? Okay, so thank you. That last question about being late to a meeting was one of my questions because it's not there. Just so trustees on the committee know, OPSPA has pushed on this new regulation very hard because some parts of it, much of it is confusing. It's created a lot of angst and problems at pretty much every board. Some parts of the new regulations contradict with old parts of the regulation, like saying, if you miss 3 meetings without excuse, then the board can eject you from your seat. But now if you miss 1 meeting, you lose your seat. And so the ministry knows that those sections contradict, and they're not budging. They've been asked about expanding the reasons for electronic participation. As you notice in the Education Act, it doesn't list work as an embedded reason, but their perspective verbally has been that the chair be reasonable in granting permission to attend electronically. So I think a frequent, in addition to people's work schedules, a frequent piece came up is that some people have to travel for their work. So if they happen to be traveling for their work, but they could still call into the meeting, would that be a valid exception? Because that is not an example the ministry gives. And the ministry's response is just be reasonable. So I think, yeah, I think it means a lot of work for the chair's office, honestly, anyway. So I think there was there seemed to be quite a few questions around some of the bits and pieces, some of the practical aspects of what's going to happen come September. And so the bylaws review committee is going to continue to work on those practical pieces, and then on the rest of our bylaws around our meeting times, meeting structures, that sort of thing, to make all of this work. Correct? Am I correct?
Through the chair, yes, there's some work that still needs to be done on the particular bylaws that could then backwards impact some of the stuff we do. What we wanted to do with PO 39 is just reflect what the Education Act requires. And it's important that we do that. And the practical aspects of it, the implementation pieces will still have to be worked on. The work of the bylaw review subcommittee can take a look at things like start time that might help mitigate the impact of this. But again, I can't speak on behalf of the bylaw review subcommittee, but it's critical that all trustees can participate in it. And this is why the survey that went out to trustees, and thank you to the trustees who did participate in it. It was important that we heard from you in order to shape the work of the bylaw review subcommittee going forward. Thank you.
Okay, thank you very much. I'll take the chair back.
Thank you. Go ahead.
Thank you. Are there any further questions? Trustee Siskrandaraja?
Thank you. Through you, Madam Chair. Just a question to what other trustees have brought up. Would the private section of our board meeting considered one of the official start of the board meeting at 4:30, or would it be the 7 p.m.?
Trustee Laskin, go ahead.
Just to respond to that, Trustee Siskrandaraja, we think given if the private session remains is thought of as a committee of the board, we would not start it at 4:30. We would recommend not starting at 4:30 in private because of the issue of having to be in person. So that's the whole conversation about understanding trustees' work and understanding trustees need to be in person. That's there's still some conflicting understanding of whether private of the whole board would constitute the whole board under this regulation or not. But regardless, I think we're really mindful that if we have to be in person, it is very difficult for some members of the board to arrive by 4:30 in person. So I hope that helps.
Okay, so thank you through you, Madam Chair. So my understanding is we're still deciding, or the committee is still working out if private it's considered part of a board meeting. Is that what I got from that?
Yeah, that's correct. So the definition in the legislation is full board meetings and committee of the whole. And how we define committee of the whole lives in our bylaws. So that has to be reconsidered within our bylaws.
Thank you, Madam Chair. And PPC, we're still deciding if we want to consider that as a committee of the whole.
Correct.
Thank you. And Madam Chair, I know it was mentioned in the presentation that we would have more details on what constitutes an exception on the grounds of family responsibilities. Is there more to say on that? Because I didn't see us going into that in deeper detail.
Yeah, sorry. Associate Director.
Sorry, through the chair. We have lots of paper on the table. So under the definition section of P39, family responsibilities is defined as essential duties such as providing care, supervision, or emotional support to family members in situations involving illness, education, childcare, or other necessary family-related activities. This is based on some research that the policy department has compiled. And it's also very important to note that the definition of family is set out in section 6.3.3E. So for example, the member of the board's spouse, parent, step-parent, foster parent of the board member or the board member's spouse, a child, stepchild, foster child, or a child who's under legal guardianship of the member of the board or the member of the board's spouse. And again, these definitions are taken from the Education Act in terms of who's defined as a family member, by the way. A relative of the member of the board who is dependent on the member of the board for care or assistance, and then a person who's dependent on the member of the board for care or assistance and who considers the member of the board to be like a family member.
Thank you. And through you, Madam Chair, if there's any more information, maybe in terms of what OPS was doing, especially around clarification and advocacy, does that mean trustees with young children could have, they would be like providing childcare? Would they have like an exception? Would you have to apply every month? I'm just trying to see, especially what OPSPA is doing, as we want to obviously encourage more young folks to enter politics, especially young women. And I think like childcare is obviously a barrier in many fields, especially in a job like this where, you don't really have daycares open until 12 o'clock at night. Sometimes our meetings go. So yeah, what's sort of the update on that?
So I can speak to that. So yes, OBSPA has had conversations for both at the level of like the assistant deputy ministers and staff, and the response kind of repeatedly is that the chair should be reasonable in granting exceptions, and that individual boards should be looking at their meeting structures and times. So the response back in terms of, child and your specific example did come up in speaking with the deputy minister was, how do we how do we encourage, people who aren't, haven't very often necessarily been in this role, single parents, people with young children who need childcare, that sort of thing. And the response is fairly consistently, look at what your board is doing and are you at the board level supporting this? So there's been multiple rounds since this this regulations were first proposed. And I would say the ministry is not budging on their language. But their responses have been much more, lenient's not the right word, but their responses have been much more flexible than what's structured in the legislation. It's kind of, I guess you'd say the response is, go make it work for you.
Thank you, through you, Madam Chair. So what are we doing at the bylaw a subcommittee level? Are we proposing any clearer language on this? Do we have the flexibility to come up with some language around this to build in, as opposed to just leaving it sort of up to sort of this informal system where you would have to write to the chair every month?
I'll take a crack at it and then go to our legal associate director. We have provided the definitions. I believe we've provided the definitions. We've provided the flexibility of up to the last minute. But I do think, I do think the default is one meeting a month to be in person. So I am not sure about a regular, I don't think we contemplated, let's put it that way, yet. We have not contemplated some mechanism to excuse consecutively as opposed to the individual meeting. And Associate Director, if you'd like to add to that, please go ahead.
Through the chair, the member can make a request, and the request could be, I would like to attend the next meeting electronically, and that's the request that's reviewed by the chair and approved or not approved. The member can request, I would like to attend electronically for the next X number of months for childcare responsibilities or elder care or whatever is considered as defined for family responsibilities. And that's the request that the chair will be having to review and approve or not approve. So again, the request has to be very clearly set out with the information that's required for the chair to make a decision.
Thank you, that was helpful.
Do we have any further questions on this item? Seeing none, could I get a mover and seconder, please, for this updated policy P039? Trustee Lasker?
Trustee Bay?
Oh, let them do it.
Oh,
I'm
okay.
already.
Heard Trustee Pay and Trustee Siskandraja. And could we open the vote, please?
Trustee Pay in favor?
Trustee Nunziata in favor.
It hasn't come up yet, Madam Chair, to make it simple. Oh, here it is.
Trustee Patel in favor.
Siskandraja in favor.
Okay, that carries. Thank you very much.
Madam
and-
Chair,
Yes,
I have a business arising motion.
yes, go ahead, Trustee.
Thank you. All trustees, I believe, received this. It was part of the blue folder. The issue stems from the fact that although the members of the committee were appointed until our term ending November 11th, 2025, one of the, in January, when the subcommittee was established, it said we needed to finalize recommendations to the board by the end of June. that would mean they'd really have to come to the May meeting, and we're not quite ready yet. So the motion under consideration is that the date for the bylaws review subcommittee to report back with recommendations for amendments to the board bylaws be changed from June 2025 to October 2025. We're not quite ready to report back, and we want to ensure we do a good job that allows for us to hear the voices of all trustees. So that's the reason for moving that amendment. I mean, the business arising, Madam Chair. Thank you.
Okay, do we have a seconder for this?
I hope so.
I
This
can
kind of-
second. I can second.
Okay, thank you, Trustee Pay. Do we have any questions? So this is a business arising motion to extend the timeline for the final reporting of the bylaws review subcommittee to October 2025. Any questions? Seeing none, could we open the vote on this, please? Oh, vote is open.
Yeah, Trustee Bay in favor.
Laskin in favor.
Chris Roger in favor.
Patel in favor.
Nunziata in
Awesome, thank you. That carries.
And Madam Chair, may I make one more comment?
Yeah, certainly, go ahead.
Thank you very much. A lot of work has been done today by the committee, and we'll make sure that you have copies of the final documents that have been recommended by the committee, as well as red line versions. So you can see the changes, and they'll be in the board package. Because the presentations, although they're helpful, I'm imagining people would like to read the actual procedures and policies. So we'll make sure to provide those. And I just wanted to make that point, Madam Chair, to all trustees.
Madam Chair, I just have a question to Trustee Laskin. So you recommend this including in the next board agenda package, or it's not like a separate package, right? Would that be nice that we provide a separate package to all the trustees? Because I think the bylaw is so important. I just don't want to be embedded into, to the
Certainly.
agenda.
No
Yeah.
problem, Trustee Pay. We can do it in advance of
That's
the
right. I
agenda
really appreciate
package.
Trustee Laskin.
No
Really
problem.
appreciate it. Thank you, Madam Chair.
Yes, these bylaw reports have always been a bit messy compared to the, making what ultimately goes forward for a decision. So thank you very much. Thank you very much to the bylaws subcommittee and to staff supporting for all the hard work in a short period of time so far. And our last thing is I need a mover to adjourn. Do I need a mover to adjourn? Yes, I need a move. I need a mover.
Trustee Pay.
Trustee
Thank you.
Patel.
And thank you very much, Trustee Patel. All in favor? Say aye. Any opposed?
Aye.
Thank you very much. Have a
you,
good
Madam Chair.
evening, everyone.
Thank you very much, everybody. Thank you, Madam Chair.